I'm Don Frederico, and this is Higher Callings. The act of governing is an exercise of power. Part of the genius of our Constitution is that it doesn't place all the power in a single ruler, but distributes it across three branches: the legislative, which is Congress, the executive, which is the president and federal departments and agencies, and the judicial, which is the federal courts. This is what we call the separation of powers, a fundamental principle of American constitutionalism. And when we talk about checks and balances, we often are talking about how each branch, when necessary, exercises its own power to limit the power of the other two branches. The last few years in American politics have given us an advanced course in these basic principles. We've seen the House of Representatives exert its impeachment power over the president, only to be stymied by the Senate's unwillingness to convict. We've seen presidents attempt to circumvent the power of Congress by issuing executive orders to accomplish what Congress was unwilling to do. And we've seen the courts exert their power over those presidents by striking down executive orders that they believed exceeded the president's authority. Ultimately, the United States Supreme Court is entrusted with the power to determine whether the legislative or executive branches, and even the lower federal courts, have exceeded the bounds of their constitutional powers. In its last term, the court issued several decisions that have arguably resulted in significant shifts in the balance of power among the three branches. A number of those decisions concern the allocation of power between administrative agencies on the one hand and the federal courts on the other. Another decision, which is still making major headlines, was the court's decision in Trump versus United States. In it, the court, for the first time in American history, immunized a former president from criminal prosecution for official acts the former president engaged in during his presidency. Last year, Suffolk University law professor Renee Landers joined me as my guest on Higher Callings to unpack some of the major decisions from the court's 2022 term. I'm pleased and honored to have Professor Landers back this year to discuss some of these cases from the court's most recent term, their implications for the separation of powers, and what they may portend as we enter a new era of single-party control over the federal government. Professor Renee Landers. How are you, Renee?
I'm well, Don. Thank you very much.
Thank you for joining me again. We did a session for our listeners. I'll just say this is the second time you've appeared on the podcast. We did one in, I think, July maybe of 2023 after that Supreme Court term, and we talked about a number of the Supreme Court decisions from that term. And we've been talking about doing another one. This time we're going to do it a little differently. As you and I have discussed, I think we'll talk a little bit about some of the cases that came out of this past term. But I think we're going to focus a little more on separation of powers and what these cases, but also the recent presidential election means or may mean with respect to the balance of power between the executive branch and the other two branches. How does that sound?
That sounds good. I look forward to that conversation.
And just to pin this a little bit in time, today is November 20th. So we're a little more than 2 weeks out from the election and a few months now from the end of the last term. We're actually well into, I guess, this term, the 2020, what do you call it? The 2025 term or the 2024?
No, it's the 2024 term. It's when it starts. Okay. It's the October not like when it starts.
It's not like a fiscal year.
Correct.
I should have known that.
I always have to think about it when I'm just trying to figure out what I want to read from SCOTUS blogs. So
last term was another exciting term for the Supreme Court. Everybody waited until the very end when the Supreme Court released the decision about presidential immunity. But before that, there were a number of decisions concerning the powers of administrative agencies. And the reason I view this as sort of a separation of powers focus today is in part because of those decisions. The president-elect has said before that he wants to put a check on administrative agencies. That's probably saying it politely. Other people who he seems to be associated with, have talked about getting rid of the administrative state. And we already see in some of the nominations that he's going to be making for heads of those agencies a likely move in that direction. But before any of that happened, the Supreme Court was already whittling away at administrative agency powers. So one of the things you teach is administrative law. Can you tell us a little bit about what you see as some of the most important developments with respect to administrative agencies coming out of the last term?
Right. So thank you for that question, Don. I think that there were several important decisions that came out of the court last term, some of which weren't a big surprise, but a couple of them were, or at least one of them was. And the one that's been most frequently discussed is the Loper Bright Enterprises against Raimondo case, which was the case in which the court overturned Chevron deference. Previously, under this 1984 case, Chevron against National Resources Defense Council, the court had held that when courts were reviewing agency interpretations of statutes, if the statute was ambiguous, then the reviewing court, would defer to the agency's interpretation of the statute as long as the agency interpretation was reasonable or permissible. And so that, set up this rule of, a fair amount of deference to agency interpretations of statutes. I mean, there were still other tools of judicial review, even in that Chevron environment, but it did actually set up this rule of deference to agencies. And the court said in the Loper Bright Enterprises case that that in fact that rule of deference was unconstitutional because it violated this understanding that it was the province of the courts to say what the law is, dating from the Marbury versus Madison case, and that it was the court's duty and obligation to interpret statutes, and that this deference would no longer be permissible. So I would say that the court did say, however, that if Congress had clearly delegated the interpretive function to the agency, the court might take a different view about a particular statute and an agency interpretation. And the court also did say that the agency's views were not irrelevant to the consideration of the meaning of the statute. There's an older case called Skidmore, where the court laid out this kind of rule of light deference, I would say, that the court would take the agency's views into account, and to the extent that the court thought that they were accurate and persuasive, the court might accede to the agency's interpretation. But that deference was not required. So I see that case as particularly problematic because it's shifting the power from the administrative agencies, which are one step removed from the democratic process, but nevertheless can be controlled by the democratic process, to the courts, which have no constraints other than their own, set of principles and obligations to provide clear and persuasive reasons for what they do. And so I think that I think it's a big power grab by the courts. And I think it's kind of a bipartisan power grab because now we have a Republican administration coming into office. I'm anticipating a little bit the questions about the election. And if the court is going to be true to what it said in Loper Bright, that administration's administrative decisions are not going to get any deference either. And so I've always thought it was kind of puzzling that people would argue that agencies should receive no deference because the deference benefits whoever happens to be in control of the administrative agencies, and it's kind of neutral and in that regard. So that's one.
Let's pause on that for a minute. That case factually involved fishing and regulation of fishing. Can you talk about what the facts were a little bit?
Sure. There's a federal statute that requires the Federal Marine Fisheries Agency, which operates out of the Department of Commerce, to monitor catches, commercial fishing catches for certain fish populations to try to ensure the sustainability of these species of fish, that are that go into the food chain. And Congress passed a statute requiring monitoring on the fishing vessels, certain fishing vessels. But in one of the statutes didn't actually say who should pay for the monitors, right? Whether it should be the government or the regulated entities. And so the agency decided that it didn't have the money to pay for the monitors, but it was actually required substantively to engage in the monitoring to protect the fish populations and the sustainability of the fish populations. So set up this complicated structure for determining when the commercial fishing vessels would have to pay for the monitors. And there was a case in the First Circuit and then the Raimondo case, Loper Bright case, in a different circuit that set up this circuit conflict. And the court had to decide whether the court should defer to the agencies in upholding the agency decision that the commercial fishing operations had to pay for the monitors.
Right. So it was basically saying there was a gap in the statute about who should pay for the monitors. And under Chevron deference, the courts were supposed to defer to the agency's decision. And here the agency had decided that the fishermen, the fishing company was required to pay. And
Correct.
They had, as you say, a structure for that. And the Supreme Court came in and said, well, they have no authority to do that. Congress did not delegate authority to the agency to say who should pay for the monitors. It's a question of statutory interpretation, and that's what the courts are there for. So we're not going to defer to the agency in doing that. To the extent there's any deference at all, it's going to be Skidmore deference, which is much less deference than what Chevron deference was.
Right.
Have I got that? Is that a fair?
Yes. I would say that's fair. That was fair.
So I guess what amazes me about some of these cases, and this one in particular, is Chevron was a doctrine of judicial restraint. And that was always a theme, usually of conservatives, politically or on the court. It was certainly when you and I were young lawyers, judicial restraint was usually a doctrine you heard, at least in my memory, coming from the conservative side of the political and judicial spectrum. And now you have the conservatives taking that away and saying, no, the judicial branch really has this power that we've been deferring to the agencies, which are executive agencies, not judicial agencies, and we have to take it back. It's part of our Article 3 responsibilities in interpreting statutes, in interpreting ambiguous statutes. Doesn't mean the agencies don't have other kinds of decision-making, fact-based decision-making for which we would be more deferential. But in terms of saying what the law allows, that's something for the courts. So to me, it's interesting how after 40 years or so since Chevron deference came into being, we're now back where the court is saying we don't think judicial restraint is really appropriate in this circumstance. We think that courts have to take an active role and take that power away from the executive branch. What do you say to that?
What I say is that, so first of all, you mentioned the 40-year duration of the Chevron case decision and rule for decision for lower federal courts. So it's another example of the Supreme Court, this current Supreme Court, really having very little respect for its own precedents. So that's point number one. Point number two is that it is true that the Supreme Court itself had not used the Chevron methodology in a case since about 2015 or 2016. So clearly it was kind of disfavored by the court in recent years. Point number three, however, is that the lower federal courts relied on Chevron extensively in deciding some of these administrative law cases. And I think that the lower federal courts, that this decision in Loper Bright Enterprises is putting a big burden on the lower federal courts on this statutory interpretation front. And I think that that is going to be a big workload burden, and it's going to result in what was the case previous to the Chevron decision, which a lot of inconsistent decisions around the country, because each court is going to be saying, well, we're going to look and see what we think the statute means. And one of the virtues of the unsung virtues of the Chevron doctrine was it unified the interpretation in the agency's view. Now, the court says in Loper Bright that one of the counters to that argument is that agencies did tend to change their minds over time, right? When a Republican was president, the Republican might say, oh, we can't require the private sector to pay for the ship monitors. And then, obviously Loper Bright, the rule challenged in Loper Bright was a Biden administration rule. Oh, we can put the burden on the regulated parties, right? And there are all kinds of examples of this flip-flopping back and forth. But I think that's okay, because I think that's what elections are for. And we elect people to be the head of the executive branch because we think they're going to take a particular point of view about the exercise of federal power. And the inconsistency may be inconvenient and troublesome for the regulated entities. But at the end of the day, that's what we're doing when we elect a president.
In my mind, it's such a complicated issue, partly for this reason. It is still a power grab, I guess, from the court, taking power away from the agencies. And as you say, the agencies are under the control, to some extent, of the president. They are executive branch agencies. And maybe when there's an election, a democratic process should allow the results of the election to filter down to the agencies, and they're going to have changes of agency heads whenever there's a change of administrations, or at least when a different party comes into power. But I guess there's this other thing kind of in the back of my mind, that what if you have a president that you don't trust? And what if you have a president that makes bad appointments? Now, I'm saying that hypothetically, but, we're seeing what's coming out of the White House, or the future White House now. And there's a lot of controversy over some of these appointments. Might it not be a good thing to bring that power back into the branch that is supposed to be, in theory, non-political, and not only where it doesn't change as quickly as the executive branch changes politically? You don't have every 4 years a potential change that's going to take power from one party and put it in the other party. So there's some stability there, but it's also much more insulated from political processes and political pressures than the executive branch is. So could Loper Bright actually be a policy that protects us from executive branch overreach, which I suppose the people that support the Loper Bright decision think that's exactly what the court did. But maybe there will be a time when people who currently are opposed to the Loper Bright decision might also be kind of grateful that the court did that. What do you think?
Well, so first of all, I think you have a far too benevolent view of the federal courts right at this moment in time.
Okay.
I don't think...
Well, again, it's hypothetical.
Right. No. Yeah,
okay.
Right, exactly. But I will say, even under the Chevron doctrine, one of the it was, first of all, the statute had to be ambiguous and not and be silent about the particular question at issue. And second, the agency's interpretation had to be reasonable and permissible. So it wasn't as if the agencies got a total free pass on any crazy interpretation of these federal laws. There was this baseline of reasonableness and rationality in relation to the statutory enactment by Congress that was the test of whether the agency's action was okay. And so I think that this idea that the agencies, could run amok under the Chevron doctrine is not correct. And I think the court kind of glossed over that aspect of things.
What was the track record, Renee? What were agency determinations under Chevron nevertheless being overturned by the courts?
I'm not sure. I don't know.
Reasonable?
I have no statistics on that. I'm sure
Okay.
that might be. And actually, I know that some of my colleagues in the administrative law space, Chris Walker and another co-author who his name is escaping me at this moment, have done some empirical work. But Chris Walker, I would say he would admit to being, sort of on the conservative side end of the spectrum. And I don't think that he ever necessarily thought that Chevron was the worst problem with what administrative agencies were doing. So I think that it'll just be interesting to see whether the removal of the Chevron approach will actually result in actually greater chaos than every 4 years, flip-flopping between an agency view. Because I dare say, based on the results of the November 5th election, people think they have the view that what the FTC is doing should be changed in terms of enforcing antitrust laws, enforcing rules that eliminate most non-compete agreements and employment contracts. I dare say that they really think that a lot of some of these federal policies should change. And so, and I think that Chevron protected the ability of agencies to do that.
Now, you wanted to talk about another case. Which case were you focused on?
The one that was the surprise, maybe I'll talk about that one, was the Corner Post case against the Board of Governors of the Federal Reserve System. And this case involved a challenge to a regulation about the prices that retail establishments pay for financial transactions. And the rule that was challenged in the case had been adopted, in the 2010s, the 20-teens era by the Federal Reserve Board. And the plaintiff in the case, Corner Post Inc., did not exist at that time. So Corner Post enters the market understanding what the rules are for these financial transactions. But Corner Post challenged the regulation and alleged, there's a federal statute that sets a statute of limitations for purposes of suing the federal government at 6 years. And the statute says 6 years from the time the claim accrues. And the Supreme Court agreed with the plaintiff and said that from the time the claim accrues language meant from the time the rule affected the plaintiff. And everybody previously had kind of assumed that it was 6 years from the time the agency adopted whatever the policy was that was being challenged. Right. And so now I think this is another, moment for creation of chaos, because no agency action is final and insulated from some aspects of judicial review until, at any time, because you can set up any kind of new company in the market and say, hey, I'm here now and I don't like this rule that it's been in existence for 20 years and I get to challenge it. So this decision, even though it was surprising and an engine for chaos, it is something that Congress can fix, because that Congress just needs to patch a statute which says that from the 6 years from when the claim accrues means, and that means 6, and just sort of either eliminate that language or add language that says, or when the agency action becomes final, 6 years from that date.
But what do you think is the likelihood that Congress would do that? At least the current Congress.
Yeah, well, I think that this one might be one where there could be some bipartisan agreement, because, again, if the argument is that people want, some kind of stability in the law, having this kind of open season on challenges to the rules seems unwise, that even people who don't like a rule like to know what the rule is. And if it's always up for grabs, that's kind of a problem.
Yeah.
So I could see this one being a change that a Congress could get its mind around adopting.
These were both 6-3 decisions, weren't they?
Correct.
So you have the 6 Republican-appointed justices in the majority and the 3 democratically appointed justices in the minority. And there were pretty scathing dissenting opinions. I think, was one written by Justice Kagan and one by Sotomayor, or were they both Justice Sotomayor?
Actually, Loper Bright was 6-2 because, going back to my earlier memory lapse, because Loper Bright came out of the D.C. Circuit and Justice Jackson was on the panel, but the Supreme Court added the First Circuit case, which is called Relentless against, marine fisheries and wildlife, so that she could actually participate in actually the decision because, obviously it was a significant one for the court that term. But you're right, the corner post was 6-3. And then there's another one, however, this Ohio against Environmental Protection Agency case, Ohio against EPA, where the court really, in my view, seemed to impose a really high bar for agency justification of rules. And that case was decided 5-3 with, I'm pretty sure this was the case, where all the women were opposed, were in the minority, in the dissent, and all the men were in the majority. So, that's the first one that I can remember where that gender breakdown has occurred. And Justice Barrett,
really interesting.
wrote a good dissent saying the agency actually did a pretty spectacular job at, justifying its rule. And we can't just go picking through a record and finding like small little problems and saying the whole rule has to go out. But that was one where it was kind of an interesting split.
I don't want to stay on this too much longer, but there was also a very interesting SEC case in front of the Supreme Court. The SEC had a procedure for years that allowed actions for civil penalties to be brought administratively by the SEC, decided by SEC people, insulated from judicial review to some extent, at least on the fact-finding stage of the litigation. And the Supreme Court said again that no, there's the courts have to be involved. There's a right to a jury trial for an action for civil penalty under the 7th Amendment. If I'm getting this right, correct me if
That's
I
correct.
say anything
That's correct.
wrong here, Renee.
No, that's correct.
Again, that SEC decision was another example, I suppose. And I'm not getting into the merits of these, either the majority opinions or the dissenting opinions, because I think they're complicated issues and we just don't have time to dissect them. But it's another example of the court taking away power that an administrative agency thought that it had and that it had been exercising for some period of time. So I guess, Renee, my question then, looking at all of these cases, is what kind of shift, even before the election, even before we had a president-elect who wants to take power away from the administrative agencies, at least that's my interpretation of what I've been hearing, what's the court doing? Has there been a shift in power and a change in the separation of powers between the executive and the judicial branch that is reflected in these decisions?
Well, yes and no. We haven't even talked about the immunity case, but see, all of these cases that we've been talking about represent a transfer in power from the agencies to the courts, because now the only option for the SEC to pursue some of these fraud enforcement actions is to bring a proceeding in federal district court. And one of the reasons that agency proceedings have been very useful in enforcing the law is because, first of all, the Department of Justice does not have time to actually litigate all these cases in the federal courts. And second, it's a huge burden on the federal court system. So regardless, even if we're to shift only some of them from the agencies to the federal courts. And so I think that the court was insufficiently considerate of what the workload effects might be on the lower federal courts. Second, I think that it does represent this idea that we're going to have to look at all of these federal statutes and agency proceedings that allow for administrative forums. We have to look at whether, under the rationale of the Jarchese case, the 7th Amendment should apply, and therefore some of the people who are the subject of these enforcement actions or these proceedings have a right to a jury trial. So I think that's going to be a long slog to figure out where does this decision apply to certain proceedings and where can the agencies go on and continue doing what they've historically done. It also raises, there's a case called Atlas Roofing that's an OSHA related case, enforcement action, that actually said that the proceedings to enforce these workplace safety laws were not, the purpose of them was to enforce public rights, not private rights. And therefore they were outside that Seventh Amendment civil jury trial provision. And so it calls into question whether the court is going to go back and look at Atlas Roofing. They say in Jarchese that they're not doing that, but I think that they've laid the groundwork for the ability to do that. And so I think that there were several points. The other final point I want to make, and this is kind of hasn't been talked about, and I probably should get pen to paper soon before someone else comes up with this idea, that the Seventh Amendment is one of the very few remaining elements of the Bill of Rights where the court has not said that through the 14th Amendment, the Seventh Amendment right to civil jury trial applies to the states. I'm sure that people are going to be making that argument, and that could have a profound effect on state administrative law procedures. So I think the potential is that this case could reach beyond just what the federal government does, but also reach the states as well.
Now, you mentioned the immunity decision, too, the presidential immunity decision, Trump versus United States. It was a long anticipated decision that created a whole new law on the scope of presidential immunity. I think everybody used to think the president was not above the law. The president wasn't a king. If the president committed a crime while in office, whether it was in his official duties or his unofficial duties or his unofficial personal interests, all of that would be subject to potential criminal prosecution after the president left office. Now, the Supreme Court, as I assume all of our listeners know, has created a whole new regime which classifies things by whether they're official responsibilities of the president or not. And if they are official but not part of the core functions of the president, which I don't think the court was very clear in defining, although maybe that's just me, then there's a rebuttable presumption of immunity. But how do you rebut it? And, what are the standards that apply? And the court really didn't address a lot of those questions. But this whole new regime now, you take away certain powers from the administrative agencies, shift them to the courts. That seems to weaken the executive branch in certain ways. But this incredibly strengthens the power of the presidency. So I don't know if you want to try to reconcile those. Maybe it'd be better if you just talked about your view.
Yeah, I think you're right. I think that this case does perhaps tilt in the other direction. But I'll say one more thing about those administrative law cases before,
Sure.
Because if the court's major idea is that the political branches should control the content of what the agencies do, then to the extent that, a president can take steps to control the personnel, this will shift into our other conversation, to control the personnel and to find people who have unlawfully and unconstitutionally a primary loyalty to the president instead of to the Constitution and the laws of the country. And if the president is able to control the personnel that way, those reductions in agency powers that we've been talking about, they might actually not prevent the president from doing things to bend the executive branch to the president's will, instead of saying, what is the law that Congress has enacted and how are we going to enforce it? And we may have, people may have various opinions about what the law means and is, but we can sort that all out in the actions that the government takes. And so that, it seems to me that we're going to centralize that control. And if you combine that with the Trump against United States immunity decision, so there are two things about that. Because remember when John Roberts was at his confirmation hearings and he said, Oh, I'm a very modest judicial person. I think I'm just calling balls and strikes. And I
Judicial
think
restraint. Yeah.
and the principal role is to decide only what needs to be decided, to decide the case, and not other kinds of things. And in Trump, the United States, they write this opinion that attempts to decide for all time what
Right.
immunities the president has from prosecution, instead of just deciding, is the president immune from that particular prosecution that was at issue in that case?
One of the justices even said, right, that it was taking them a long time to write the decision because they were deciding it for the ages. I
Yes,
think that
yes.
was Justice Gorsuch, maybe.
Yeah, there was just this course of complete judicial arrogance and hubris, in my view. So I do think you're absolutely right that what we have now is, and so it's not even the immunity part that's the interesting part, because the court in all of these public corruption cases recently, not all of them, but in many of these public corruption cases recently, has been setting this incredibly high bar for a criminal prosecution of a public official for engaging in activities, to benefit private persons and to take private remuneration from government decisions. So in some ways, the Trump v. United States is kind of just a continuation of that trend, which I think is really appalling, but that's, beside the point. But the really interesting aspect, I think, of the opinion is the effort in Trump v. United States is the effort to say that there are all these actions of the president that are that exclusively belong to the president, and that no other branches have any role in policing the boundaries. And that, I think, is the really dangerous part of the Trump v. United States opinion.
Right. One thing that concerns me is the spin that this case has been getting is that the president is absolutely immune. There's no way to ever prosecute a president, a former president, I should say, for actions taken while the person was president. And you even see it in the dissenting opinion, which talks about how far this goes, and you'll never ever be able to prosecute a president for anything they do while in office. That's not what the opinion says. And I don't know. I've read other Supreme Court cases where the dissent would try to minimize the effect of the majority's decision because strategically they want people to understand that, yeah, you keep fighting these cases because you can pick away at the decision of the majority. When a dissent basically throws up their hands and says, that's it, we've lost the whole thing, they don't leave much room for debate about how far does this really reach. And I just think strategically if I were a justice, I wouldn't want to make that kind of concession, which I interpret when I read the dissenting opinion.
Yeah.
But I guess the other thing is, how far does this really go? I mean, Justice Roberts was careful to delineate different categories of things that could or could not be prosecuted. I think the majority, whether you agree with the decision or don't agree with the decision, at least tried to justify it by articulating to some extent some limitations on the scope of the decision of the immunity. But the press, everybody seems to think this means you can never prosecute a former president for what they did while in office. I don't like that interpretation because I don't think it's accurate. What do you think?
I agree with you about that, but I think what it does do is make it very hard for the prosecutors, right? And it's very hard for prosecutors to bring an action that won't be criticized as being political. The other thing I want to say about this case is that the court erects all these reasons for why it is that we need to protect the president so that the president doesn't have any, can do what the president thinks is best for the country and doesn't have any fear of subsequent prosecution for actions taken.
Right.
Okay, that has never happened in the recorded history of our country. So this was a decision solving a problem that didn't exist. And so, and if a president does do something that should be prosecuted, I mean, I think we should be able to do it, but I think that the court was just setting up this kind of red herring of horribles about the president fearing subsequent prosecution and refusing to take action. We've never been a country that has done that.
Yeah. So these decisions that we've talked about were all decided while there was a Democrat in the White House, while Congress was divided. You had a Republican majority House and a Democratic majority Senate. And now, in a couple of months, we're going to have a Republican government from the White House to Congress. And given the composition of the Supreme Court, you would argue that that's a majority Republican Supreme Court. Do you think that Justice Roberts and maybe one or two other justices might tap the brakes a little? Do you think they might be concerned about how disproportionately powerful the Republican Party is now going to be in our government, and especially now that there are some rather extreme views and intended actions among those Republicans who are going to be populating the executive and the legislative branches? Do you think the court might want to, in order to protect the institutions of government, which I think to some extent Chief Justice Roberts has done before, especially, for example, in the litigation over the Affordable Care Act, where he disappointed his own Republican colleagues, as I recall it at least,
That's
when
correct.
he voted to save the Affordable Care Act. Do you think there's going to be that kind of instinct? And to maybe tap on the brakes a little bit and not let this go too much to the extreme under a new administration and a new Congress?
My short answer to that is no. I think that Chief Justice Roberts, the high watermark of that attitude in his, well, actually, no, that's not entirely correct. So that was one set of cases, the Affordable Care Act cases, where he did actually demonstrate some restraint and deference to, the political branches. The Congress had decided on the law, and, we're going to make the law work because that's what the Congress and the president wanted or had decided at a moment in time. The other case where he seemed concerned about these institutions of government was the Department of Commerce against New York case, which was the case that involved whether to add a question about citizenship to the census for the 2020 census. And there, he had previously, on the cases involving barring people from certain predominantly Muslim countries coming to the United States, said, well, the president may have some good reasons. And, so we're going to let it happen, even though the rationale didn't match the restraint on people entering the country. But then when he got to that census question, it was very clear that the government had lied about how the impetus to add that question had come about, and he was having none of it. And so that's why he sided with the challengers, saying that question, that it was fine to exclude that question from the census in 2020. I'm quite sure, as a footnote, that issue is going to come back around again. But anyway, and because the government, the presumption of regularity about the government's actions had been rebutted in the course of the litigation. And I can go into more details about that. But the larger point is that, so he's done those two things. And then a third area was, even though he voted with the majority in the Dobbs case to uphold the Mississippi abortion statute, he only occurred in the judgment because he said he would not have gone so far as to overturn Roe v. Wade and Casey, that it was unnecessary to uphold the 15-week abortion ban in the Mississippi statute. But he couldn't get anyone on the majority to go along with that point of view. He obviously failed in that effort. So I think he is unable to control his colleagues on the court in exercising that restraint for the most part. And I just don't see, I think maybe he's given up, and I just don't see him doing it going forward.
Yeah, I guess maybe I'm, again, too optimistic. I'm thinking of the Students for Fair Admissions case, right?
Right.
The one against Harvard. I think he wrote the opinion in that, didn't he?
Yes.
And at the very end of the case, he kind of created this loophole for people to talk about race when they write their essay for college admissions. And he said there's nothing wrong with that. And of course, the colleges can consider that. So that was him adding something to his opinion that kind of took it back a little bit off the ledge, which he didn't have to do. And it wasn't necessarily enough. And you can disagree strongly with the court's decision, but at least he did that. And so maybe that was a signal that there's still some places he won't go. You've also got a number of cases where people cross party lines on the court. I mean, you mentioned Justice Barrett had voted with the minority in one of the cases we just discussed, the one that was split along gender lines. So I guess there's a part of me that still hopes that there are some extremes to which this court won't go, because there are some members of the court that will hold it back at least a little bit.
I hope you're right, but I think it might be the rare case where he does that. I mean, it will be interesting to see. I mean, you mentioned Students for Fair Admission. There's a case that's been sitting on the petitions docket for I was going to say weeks, but maybe even months now, which raises the issue of the new school assignment process for the elite high schools in the city of Boston, which is race neutral according to the criteria the court has already used. So it'll be interesting to see whether they take that case and whether, that'll be an opportunity for a next statement about some of these implications for considering race in education, or what counts as a neutral criterion. I think that's really a more accurate way to phrase what the challenges relate to now. So there might be another opportunity there. Also, the court said that they didn't preclude the military academies from using race in their admissions processes. And so those policies are under, there's litigation about all of the service academies now about their use of race in their admissions criteria. So I have to think at some point that is going to get to the Supreme Court. Now, with a new president coming in, I think that there probably is going to be extensive pressure on the military to eliminate any kind of use of race in anything in the military, even though the military has been one of the leading lights for trying to push society out against segregation and discrimination. And so you could see that coming. It just depends. I don't know enough about, the civilian control of some of these policies that the military adopts, how easily the new president might be able to affect that change, which could make the litigation go away.
I was listening the other day to a podcast. It's actually the What a Day podcast of the New York Times, the November 18th edition of it. And there was somebody from the ACLU who seemed very optimistic that to the extent people believe that the next administration is going to be overreaching and potentially violating people's rights. The ACLU in the last Trump administration had filed 434 legal actions, and they're apparently ready to go again, hopeful that that would be effective, not only because to some extent it was effective in the first administration, but also because of the lower federal courts, which really are the places where the action is, even though we talk about the Supreme Court, but the Supreme Court only takes 60 cases a year, and they can't deal with all of the things that are going to be happening at the district court level. Now, maybe our district courts are going to be overwhelmed, especially after Loper Bright. But what do you think about the effectiveness of the federal district courts to keep any overreaching administration in check?
Well, I mean, I think that there is something to that argument because, going back to the abortion cases before the Dobbs decision, the two cases immediately before that the Supreme Court decided involved regulations of the facilities in which abortions could take place in Texas and in Louisiana. and also a requirement that physicians have admitting privileges at a hospital to take care of complications that might arise from an abortion procedure. And the district court decision in the Texas case, which was the first one, it's called Whole Women's Health against Hellerstadt. The district court decision in that case did an extraordinarily excellent job of fact-finding to demonstrate how the policies of, the admitting privileges and the facilities requirements absolutely had nothing to do with safety of the procedure for the women undergoing the procedure. And then the court, basically the Louisiana statute in the June medical case that was a year or two later, it was almost the identical statute. And this is going to be to your point about Chief Justice Roberts, where even though he had dissented in the first case, he went with the majority striking down the Louisiana law, saying it's exactly the same as the one we struck down in Texas. We have to strike that one down too. But this is to your point about the fact finding and the quality of work of the district judges that actually demonstrated that these laws were, unnecessary and the justification for them was not rational. There was no rational basis for them. And then, even though there was a different test at the time, I think you might see some of the same things in the EMTALA case coming out of Idaho, the case about whether even in states with abortion bans, they are required to take actions to protect the long-term health as well as the life of the woman if there is a medical emergency involving the pregnancy. So I think that the role of the lower federal courts is really important. And now we've had 4 years of Biden appointments to the courts, which have, perhaps shifted the composition of the courts somewhat. You still have the problem of, these single judge divisions in certain parts of the country, particularly
Right.
Texas, where people can, shop and pick their judge, which that just really has to end. I mean, it's antithetical to a legal system where you can pick the person who adjudicates your case. And so, we should end that. And equal opportunity ended, in the liberal districts as well as the conservative districts. And so we still have the problem of the Fifth Circuit being a little kind of outside the box, and to a certain extent the 11th Circuit, but maybe that there have been sufficient appointments in the last 4 years to, kind of course correct a little bit there.
One final question. All of what we're talking about implicates the rule of law, and that's a whole other conversation, but that's really what we're talking about. And my question to you is, what can lawyers, law students, bar associations be doing to support, defend, and try to strengthen the rule of law to the extent it's coming under attack in the next 4 years?
Well, I think that's a really hard question. I think the ACLU, what you mentioned about the ACLU, being willing to continue to challenge these policies, I think it's really important. Also speaking out. There was an article that I saw recently reporting on the last week's Federalist Society convention, where it, of course, reported anonymous people saying, I don't want to speak out because I want to get a job in the administration. I want to be able to have influence in the administration. This is an approach that's really lacking in courage that we need at this time in the democracy. Yeah. And one of the reasons that we are in this position is because people have valued power and access to power over what the rule of law is. And I think that people really need to stop doing that and to really try to have their actions conform to their principles and to speak out and to call out problems of legal process and substantive policies that are antithetical to the rule of law when they see them.
Renee, thank you. That's a great note to end on. And again, I really enjoy talking to you about these and any other issues every time I have the chance. So thank you again. I'm sure our listeners will appreciate this, and you've been very gracious about going beyond the time we had agreed to. So thanks, and I hope to see you soon.
I hope so too. I always enjoy these conversations, Don, and it really makes me think a little more deeply about what I do and how I teach the cases. So I really appreciate the opportunity.
Take care, Renee.
You too. Bye-bye.
This has been an episode of Higher Callings. Your host is Donald Federico. Music is provided by Fancy Mountain, and our logo was designed by Matt Pedro. The associate producer is Brian Federico. Higher Callings is a production of Frederico Media, LLC.